Joe Exotic on the Tiger King.
Yeah. Now we're live, so if you want to announce your costumes, you can. Okay, we're live and on the record for Monday morning's civil docket for November 1st, 2021, starting with quick announcements with Mr. Gomez.
Good morning, Judge. I have number 9 on the docket.
All right, CL 21-1309-I, Leonelli Hinojosa versus Allstate. Your announcement?
Randall Gomez here on behalf of Allstate. We settled the case. We're working on exchanging settlement documents and getting the checks. And so we need about 30 days before we submit our dismissal documents.
Ooh, way to kick off the docket, Mr. Gomez. Okay, so you need about 30 days, and I have December 1st.
That's all
And
I have.
if everything's in before that date, just let us know and we'll take you off the docket.
Perfect. Sounds good.
And that'll be at 9:30.
Okay. That's all I have. May I be excused?
Yes, thank you.
Thank you.
Okay, Mr. McCallum?
Good morning, Your Honor. I have, I don't know what number it is in the docket, but it's
Number 8, Willie.
number 8 on the docket. Your Honor, Rose always helps me out. She's here. This is a post-appraisal case. We're discussing settlement. We just need a little bit more time. I think we can resolve it.
Ms. Sandoval coming in clutch for you again, Mr.
Always.
McCallum. Okay, so then how much time are y'all requesting?
Maybe 30 days, Your Honor. We should have it done before then.
Okay, Ms. Sandoval, anything to add?
No, that sounds about right. We're just negotiating now, Judge.
Okay, December 1st at 9:30.
Your
And
Honor,
may
I also
may I be excused? Because that's all I had.
Sure, thank you.
Thank you.
Your Honor, I also have number 14 on your docket, a CL 173652I, Raul Martinez versus underwriters. There is a motion for pro hoc vici. I have no objection to it. I'll leave it up to the court's discretion. I don't know the opposing counsel on this case. I don't know if they're on.
Judge, good morning. Jacob Castle on behalf of Lloyd's London. I think we have Sabina Danik also on here. She's the attorney that's requesting admission pro hoc vici as well.
Good morning, Your Honor.
Good morning, how are you?
Great. How are you doing?
Doing very well this morning. Okay, well, there's no objection. So do y'all have an order on file?
Sabina,
Are we
did
taking
you
up that
find-
motion or?
For Pro Hoc Vice, Your Honor? I believe it was submitted at the end of last week, and that there was an order attached with it, but we can double check.
Okay, can my staff, go ahead. Okay, I'll go ahead and ask for it to be sent to my queue.
Thank you, Your Honor. That's all the business I have before this honorable court.
Judge, real quick, before we reconvene on this, I think we had a hearing on a motion to dismiss for Lloyd's London. We're asking the court if you can get that reset. We're actually speaking with opposing counsel on the matter. I believe it was set for this morning. We would like to try to get that reset for, a month from now or a month and a half, depending on what the court's availability is.
Okay, can you do me a favor and just file an order resetting hearing on that and we'll get that set for you. Make sure
Absolutely.
you include all attorneys that need notice.
Okay, we'll do, Judge. Thank you.
Thank you, Your Honor. Have a great day.
Okay, thank you.
Judge.
Okay, Mr. Solis.
Good morning, Your Honor. Number 15 on the court's docket.
CL 22647-I, Hector Elizondo versus State Farm. Yes, sir.
That case is settled. We submitted to Rule 11, but I guess it was not done in a timely manner.
No.
We have received the settlement documents. We have signed the the release and return it to opposing counsel. We will forward the dismissal documents for filing once we receive the checks, but we're done with this, Judge.
Okay, so no, it was received in a timely manner, except the court doesn't accept Rule 11 agreements on status hearings, or I may never get to hear what your status is. See,
Okay.
Settlement's music to my ears, so
Okay, well, I'm singing to you, Judge. I'm singing to you.
thank you. And you're in perfect pitch. So anyway, okay, so then I'll go ahead then and set a tickler. How much time do you think you all are gonna need, or did you want me to set you up for something?
Set it up just so it doesn't fall off the document, but I work well with this firm and I don't foresee any issues. I guess the first that you gave out earlier would work for us.
Okay, December 1st at 9:30.
Okay, I don't suspect that I'll see you that date. I'm not gonna be singing to you, but in case, we'll see you
All
later.
right, if by chance you get everything in, let us know and we'll take you off the docket.
Yes, ma'am. Maybe excuse,
Yes,
have a good weekend.
thank you, you too. Okay, Mr. Guerra?
Yes, Your Honor, here number docket number 4.
Okay, and that is CL 21847-I Primo Trading versus Jack Carithers, Carithers. Yes, sir.
Yes, Your Honor. This is a motion for default judgment, Judge. He was served on May 22nd, 2020. The return has been on file for more than a requisite amount of time. I have filed exhibits 1 through 8, and first one being the 30-day demand letter, second exhibit, the proof of service and the return. Exhibit 4 is the invoices. Exhibit 5, certificate last known address. Exhibit 6, non-military affidavit. Exhibit 7, affidavit of attorney's fees. And exhibit 8, the statement of evidence, Judge, all signed and asking the court to be admitted. And also that the court take judicial notice while pleading on document and previously filed.
Okay, let me just call the defendant's name out
Mhm.
3 times. Jack Carithers, how do you pronounce his last name?
I think it's Carithers.
Okay, Jack Carithers. All right, no one has announced themselves by that name. So since the defendant is a no-show, the court will take judicial notice of all the documents in the court's file and specifically will admit the exhibits that have been e-filed with the court. And what is the judgment that the plaintiff is seeking?
He's asking for, this is a student sworn account, Judge, for produce, failure to pay the produce. 1,950 is the amount that it was previously owed, sorry. 550 for court costs, filing fees, and cost of serving fees, 18% interest until the judgment is signed until paid. As of April of 2020, a pre-judgment interest of 6% and post-judgment interest in the amount of 18% per annum from the date this judgment is signed until paid, and also $3,000 in attorney's fees. And that's the final judgment, Judge. I am gonna amend the judgment, Your Honor. I will be filing right now a first amended default judgment order for your signature.
Okay, and on your attorney's fees, did you attach the affidavit or were you going to prove it up right now?
Yes, Your Honor. That is part of my exhibits that I had that I need the court admitted, exhibit 1 through 8, and that is actually exhibit number 7.
Okay, here it is. All right.
Yes, Your Honor.
Okay, let the record reflect that I am reviewing exhibits 1 through 8, and that is exhibit number 7.
Yes, Your Honor.
So, okay, well then, the court will grant the relief as requested by the plaintiff. And as soon as you file that amended judgment, go ahead and let my staff know, and that'll be the one that's forwarded to my queue.
Yes, Your Honor. I'll file this morning. Thank you, Judge.
Okay.
I have nothing further, Judge. May I be excused?
Yes, you may.
Thank you, Judge.
Okay. Mr. Hernandez, you haven't laughed at any of my stuff. I'm not witty for you this morning.
Good morning. How are you, Judge?
I'm doing well. How are you doing?
I'm doing great. I'm sorry, a little tired after that victorious Cowboy win and a bunch of candy and Halloween festivities. So
Hey, you can tell you're a Cowboys fan because you Cowboys fans insert those wins any chance you get in a conversation. Oh, and we're making it to the Super Bowl this year, right?
that's right. Amen. I'm here with Mr. Torres on number 2 on your civil docket as the guardian ad litem. Judge, I would ask for a little bit more time because there's some medical expenditures that I've found that we need to address. And so, Mr. Torres, I believe we're on the same page so that we make sure that the minor is going to be taken care of on his medical expenditures.
Okay, and Mr. Chop, are you here on that case?
That's right, and I apologize to Mr. Hernandez. This came to my attention this morning, so I didn't get the chance to confer with him about it. But I'm looking at the issues. I've spoken with the case manager. I think we should get a resolve, so I would ask for, I guess, a brief reset or whatever Mr. Hernandez needs.
If you don't mind, 30 days, and then Mr. Chapa, I'd be happy to visit with you after the hearing. That way we can get on the page.
Okay, and that's on CL 201363-I. All right, then I can reset you all for December 1st, and let's see if you have those issues worked out by then. And that'll be at 9:30.
Thank you, Judge. May we be excused?
You certainly may.
Have a
Thank you, Your
wonderful
Honor.
day.
Thank you, you too.
Ditto. Bye-bye.
Okay, Mr. Bettis? Robert Bettis?
Good morning, Your Honor. I'm here
Good
on number 10 on your docket. Sergio Castellanos versus Archer. Just a quick announcement. We've
morning,
done
Judge. Daniel Martinez here for Mike Wise on this one, standing in. Robert, good to see you.
Good to see you. We've taken the plaintiff's depositions and we've done written discovery. We're just pending mediation on this case.
Okay, and that's on CL 190206-I. Okay, Mr. Martinez, any additional announcement?
No, Your Honor, that's all accurate.
Okay, and how much time are you looking at as far as the time frame to go to mediation?
I think in the next 60 days, we can get that done.
I think that sounds about right, Judge. There may be some ongoing discovery, Robert, in terms of DWQs and things like that, but depots are already done. So I think we've probably got most of the facts we need and we can meaningfully mediate.
Okay, and what type of case is this?
Auto accident, Judge.
Okay. I'm gonna set the deadline for y'all to mediate by January the 14th. And I'm gonna have y'all come back on February the 16th. And I will send to you an order of referral by the end of the day.
Sounds good, Judge. That's all I have. Maybe excused.
Yes,
Thank you, Judge.
Thank you, Your Honor.
yes, sir. Okay, and Ms. Martinez?
Good morning, Judge. We're number 13 on your docket. I did see Mr. Pruneda on the call. I believe his screen was black. I'm not sure
Okay,
if he's present. Mr.
Yeah.
Michael Pruneda?
yes, he's
I'm
present.
here, Judge.
Okay.
We were,
Let me
yes,
call the case. Yeah, okay, CL 194366-I. Okay, what is the announcement?
Your Honor, we were scheduled to have depositions at the appropriate time. Unfortunately, I did have a family emergency and Mr. Pruneda did work with me. We are in the process of rescheduling that deposition. He's let me know that he's going to be busy up until around the January time period, so we're hoping for a 60-day reset.
Okay. And do you think that, well, I guess let's see if those depositions do occur. And then we'll have y'all come back. What is the latest January setting that I have, Ms. Rivera?
Second, Judge.
Okay,
Judge, we have January the 26th.
January 26th at 9:30. And let's see where you all are at that time.
Thank you, Your Honor. May I be excused?
You certainly may. Mr. Pruneda, anything else?
That's all we have, Judge. Thank you.
Okay, you're welcome. Okay, Mr. Hinojosa?
Yes, Judge. Good morning. I'm here on a case with Mr. Espinosa on, it's number 5 on your docket, Your Honor.
Okay.
And Judge, I represent Mr. Reneg again.
Okay, F 3808-18-9, okay?
I thought I saw Pete. There he is.
Good morning, Judge. Peter Espinosa for Blanca Gomez on our motion to clarify the divorce decree division of asset. I have an interpreter here if he's allowed to interpret for Ms. Gomez, and I believe, yeah, she is present also.
Judge, this will be contested matter, it looks like, Your Honor. We're not agreeing to the petition to, well, the motion to clarify divorce decree division of assets, because it looks more like trying to modify a divorce decree property division. So we're not in agreement, Your Honor, and it will be contested.
Okay, then I'll have y'all come back, check back with us in about 10:30 then.
Yes, ma'am, 10:30.
Okay,
Good.
be on
Yes.
standby, yes.
Yeah, if I can just have my interpreter state that to Ms. Gomez so she can reconnect.
Well, who's your interpreter?
Eric?
Señora Gómez.
Sí.
Sí, como es una audiencia contestada, la audiencia se va a posponer hasta las 10:30 de la mañana.
Ok. Está bien.
So let her know
Oh,
she can reconnect with this link.
Si gusta esperar o si gusta reconectarse a las 10:30.
Bueno, voy a seguir conectada.
Ok, muy bien.
Gracias.
Okay, thank you, Judge. May we be
Thank you, Judge.
temporarily excused?
Yes, you may be temporarily excused. Okay, Ms. Lopez Singletary?
Yes, good morning, Judge. Nerida Lopez Singletary. I'm here on behalf of Ms. Judith De Leon, Your Honor. And I also have co-counsel Ms. Catherine Alvarado, and I think she's logging in set for 10:30, Your Honor.
Okay.
Logging in, and my client, Ms. De Leon, is present with me here in the office.
Okay.
Judge, good morning. I'm on the other side, Fela Olivares for Lamar Flores. And I don't mind waiting, Judge. I just have to leave about 11:45 to go back to the 398. We're gonna start at noon.
Okay, let me see if anyone else has any other quick announcements, and then we can.
Just text.
And then we'll go ahead and take you all back up. Okay?
Okay, thank you, Judge.
Yes. Okay, Mr. Palacios?
Good morning, Judge. I'm here with Mr. Diaz, and on the other side, we have number 11 on your civil docket.
CL 173804-I, Eugene Denby versus Celia Munoz.
Good morning, Judge Sonny Palacios and Mr. Denby.
Morning, Your Honor. Pete Diaz on behalf of Celia Munoz.
Okay,
Well,
what
Judge-
is the announcement?
So we do have a mediator with Edna CDO. We are just waiting for the date. We were supposed to try to get this done for October, however.
There was a scheduling issue. The mediator didn't put it down on the schedule or something. Yeah. So we were actually going to mediate it, and the day before we found out that we couldn't. So we have to reset the mediation at this time.
Okay, has she given you a new date?
Yes. We have some tentative dates, Judge. They look like in November, mid-November.
All right, then let's come back on December the 1st at 9:30.
That'll be perfect, Judge.
Thank you, Your Honor.
Okay,
Excused.
thank you. Yes, y'all may
Thank
be
you.
excused.
You have a wonderful day, Judge.
Thank you, likewise. Ms. Padilla?
Good morning, Your Honor. I apologize. I had to get on using my phone this morning. I also apologize because I do not know the docket number.
Okay, it's number 6, CL 191967-I, Juanita
Yes.
Garcia versus Penske.
Yes, Your Honor. We did have a hearing this morning to discuss the settlement before the courts and the 2 minors involved. However, the minor's father was not able to take off of work, and so we will need to respectfully request the court to reset the hearing.
Okay. December 1st at 9:30.
Wonderful. Thank you so much, Your Honor.
Okay, you're welcome. Thank you.
Thank you.
Okay, did we hear from number 1 on the court's docket, F 2677-21-9 in the matter of the marriage of Iris Ariasola versus Mr. Ukegbu?
Judge, nobody called in, and I do see that they filed and agreed, or they filed a motion for continuance. Let me see if it was agreed. But they didn't file Rule 11 or anything of that nature, Your Honor.
Okay,
Well, it says respondents unopposed motion for continuance.
oh, so it's his motion for continuance. Well, I'm assuming, okay, that's fine. The only thing is just, let's reach him and tell him that he needs to file an order resetting hearing so that we can reset him. But since it's a pro se respondent, go ahead and set a
Your
ticket.
Honor, I'm sorry, it's not pro se. That was Mr. I don't know how do you pronounce his last name. He did hire an attorney.
Oh,
Yes.
he did?
Yes,
Okay.
ma'am.
All right, well then let's notify the attorney that they need to file an order resetting hearing. And just set a tickler for Friday. If they don't do it by Friday, then we'll set it up, then we'll put it back on.
Judge, in reading the order, they did include an order resetting, like.
They did?
Yes,
Okay.
yes, ma'am.
Okay.
They included it within their motion.
Yes.
Oh,
It's in the order. I just saw it.
okay. All right.
It's good, Judge.
Okay, that's fine. Okay, Mr. Martinez, I apologize. I didn't know you had an additional case there.
No sweat, Your Honor. Thanks for calling me back. And it's number 12 on the docket, but one other question. On number 10, Judge, on your docket, you gave us a new setting. Am I to assume, Judge, that's also for 9:30 in the morning?
Yes.
On February 16th? Thank you, Your Honor. I appreciate the clarification. Number 12 on your docket, standing in for Karina Garza de Luna. I don't think Fernando Lopez is present. That's why I hadn't raised my hand yet, Judge. I was waiting to see if he'd appear. But
Okay,
I don't
did
see
you-
plaintiff's counsel.
Okay, do you want to make the announcement on both of your behalves, or did you want to call him, or?
No, that's fine, Judge. I'm happy to make the announcement. There's a pending offer in this case, and my understanding of the status is that the plaintiff and the plaintiff's attorney need time to confer regarding the offer to decide whether or not they're going to accept.
Okay, and that's on CL 202838-I. Well, we can come back on, I'll let you all review it for 30 days, and we'll go ahead and come back on December the 1st at 9:30.
12/1/21, 9:30. Thank you, Your Honor.
Thank you.
Take care, Judge. Bye.
Likewise. Okay, so the only thing, let me go ahead and go through the rest of the docket, since it looks like the only two issues, not two issues, but the two settings that are left that are contested. So we'll go ahead and let me see. Did anybody call in on number 7?
Judge, they filed this settlement letter with Honorable William Garza. They settled at mediation, Judge. I'll go ahead and send out an order resetting for his status just to make sure we get those documents in.
Okay. And you can set them for the 1st. I think we have like 2 spots left.
Yes, ma'am.
Okay, so then we have, okay, those 2 left. All right. Let me just take a quick 5-minute break and we'll be right back on the record. We're off the record. Okay, let me just check with my. Ms. Flores, you're good?
Yes, Judge.
All right. Okay, let me just wait for Ms. Olivares to get situated.
I'm on your.
All right, let me recall F4029-15-9 in the matter of the marriage of Judith Flores versus Lamar Flores, but really it's just in the interest of minor children, correct? That's
Yes,
correct,
Your
Your Honor. Okay, and go ahead, Ms. Lopez Singletary and Ms. Alvarado, this is your motion, or whose motion?
Yes, Your
Judge,
Honor. We filed the first amended petition to modify with the parent-child relationship, Your Honor, and a temporary restraining order with a show cause that was set for today. Mr. Lamar Flores was served in New Mexico on October the 21st at 9:04. That return of service from the process server is on file with this court, Your Honor.
Your Honor, in response to that, fellow Olivares, we do have a motion to transfer venue. As the court knows, we filed it the day we had the court hearing. And procedurally, Your Honor, you have to dispose of the motion to transfer venue first. I did file also on Friday, a response to the motion. Let me see, that's my response. I did file some more documents. And those documents are under the UCC GEA. I filed a motion for the Texas court to confer with the New Mexico court under the UCC GEA. And Your Honor, and I'll let the court see where we're going before I tell you the other part, because if you look at TRCP Rule 87, the court must, it says that the determination of a motion to transfer venue shall be made promptly. So that one has to be made because it is in question now your original exclusive jurisdiction because of the pending Mexican court. So that's where I'm going with it this morning. I'll let the court guide me and see what you're going to do so I can give you the rest of the argument. And I do have.
Okay, well, before we go to anything like that, I want to know, where are the kids?
Well, with the father.
They're still in New Mexico.
I imagine.
Judge, Miss Olivares knows that they're still with the father.
They're with the father. They're with the father.
Now you imagine, you know.
But I ordered them to be returned to the mother. So why hasn't he done that?
Judge, I told you very clear that he had to do that. He was in Mexico. I can't force him to bring him.
He's in New Mexico.
I'm sorry, I misspoke. In New Mexico, I do have the New Mexico attorney, Clayton Hightower. He'll be my witness today on their UCC GEA motion. He says that he.
Well, Judge, I have one concern, Judge. He was ordered to be here. Where is Mr. Flores, Judge? The hearing has started. He was served personally with the notice of show cause hearing, Your Honor, and that's the first thing that needs to be addressed. It's very disturbing, Judge, that they say there's no jurisdiction. However, they came to this court to have a writ signed, and they want to go ahead and abide by that. But as soon as the court goes ahead and modifies that or changes that, now they're saying there's no jurisdiction. We need Mr. Flores to be present. He was ordered, Judge. We got him served. The citation is on file. Where is he, Judge?
And Ms. Singletary, you're correct. Mr. Hightower is going to appear for him because he says that he is his attorney in New Mexico. Wait a minute, please. I've got 2-3 against me.
No,
that's how I feel.
We're not speaking.
Okay, hold on. Because if not, we're not going to have a clear record.
Right.
I am not against you. I am for justice and I am for the rules. Now,
all right.
I did review the file that was properly served. He was ordered to return the children and he hasn't. So that already tells me that he thinks he's above me or he's getting some bad legal advice from. I'm not saying from you. I'm just saying in general. Now, second, he was ordered to be here today and he has not logged in. I will not accept the appearance of his attorney today in substitution for his appearance. He must appear. So I will give you an opportunity to contact him and get him on. Now, I also stated that if he didn't return these children, I was going to consider issuing a warrant for his arrest for not following the court's order.
Judge, you understand everything you're telling me, but there is procedure, and that procedure was Miss Judith, and I'm gonna say the Leon.
And Your Honor, that procedure was not
Let me
followed from
finish,
day.
please,
That
Judge
procedure was
Singletary.
not followed. Ms.
Okay, you
Olivares,
see, I can't
spoken-
talk
I
because
need
they
more
interrupt me.
Hold on.
Okay, I was saying, Your Honor.
No. We're not gonna, this is what's gonna happen.
Well, Judge, wait a minute.
No,
With
I'm
all
not
due
gonna
respect-
I'm not gonna issue a ruling on anything. Just wait. Listen to what I'm going to say, please. First of all, there's an order, and you're right. You cannot force your client to bring the children. You can only advise him what the court has ordered, and the rest is on him. So what I need to know right now before I move on and say anything is, will he be bringing these children?
I don't know, Judge, because he didn't bring them when you told him. I can't answer you that question, but I think we need to follow the rules procedurally.
No, and you're right. We do need to follow the rules. So this is what I'm going to do as far as following the rules, because apparently it is difficult for, first of all, us to do this on Zoom. Number two, your client doesn't seem to be listening to you, nor listening to me. So I am ordering him to appear in person on Friday at 9:30 a.m. and we're going to continue this hearing in person. This will be an in-person hearing on Friday at 9:30. If he refuses to bring the children on Friday at 9:30, I will have him taken into custody immediately. So it's his choice. So Friday, 9:30, my court coordinator will contact you to tell you which courtroom we will be appearing in. So we are in recess until then. I will not take up any further arguments from either side at all at this time. We will resume this in an in-person hearing on Friday at 9:30. And Mr. Flores is ordered to be there. And if Ms. De Leon is going to be giving any testimony, then she needs to be there as well. The children are ordered to be brought to the courthouse on Friday at 9:30. If he does not bring them, tell your client that he needs to be prepared to be taken into custody. So I suggest he not have his wallet, he not have any shoelaces on his shoes, and that he not be wearing a belt.
Your Honor, can you sign an order so I can send it to them? And that way I can.
The
And
order.
Your Honor, this is Clayton Hightower. I'm his New Mexico counsel. How are you today, Judge?
I'm fine. We were in recess until Friday at 9:30 a.m. where your client is ordered to appear in person. If not, I will take him into custody.
Your Honor, our issue with that is we have conflicting court orders. We have a New Mexico court order and a Texas court order, and we're requesting that both courts conference pursuant to the Uniform Child Custody Jurisdiction Act.
I will conference with the court, but I have already made a ruling in the previous hearing that I have jurisdiction over this. So
And so has the other court, and that's the issue.
Your Honor, I'm going to object. That is not Mr. Lamar Flores. Mr. Flores was ordered to be here, Your Honor, and now is he licensed in the state of Texas, Your Honor? Or, the court heard some arguments before and he just logs in and wants to make arguments, Judge. I'm going to object to his arguments being stricken from the record, Judge.
He's the attorney for Lamar Flores in New
Mr.
Mexico.
Flores was
And that's
ordered
the
to
whole
be here.
issue here.
Wait.
It's a matter of
he is
public record. The court
Okay.
can take judicial notice of it.
Look, we're resuming this hearing in person on Friday at 9:30, and that is it. Friday at 9:30, Mr. Flores is ordered to be there. Ms. De Leon is now ordered to be there as well, and the children are ordered to be there. Between now and then, I will see what I will do, but that's it. That is
Yes,
it.
Your Honor.
Because
Just for
there
the
is no
record-
way that we're going to be talking over each other on this screen. And I'm not going to be making a public spectacle of this case on YouTube Live right now. This is very serious, These are children's lives, people's lives that we're dealing with. And I'm not going to be putting it on for the world to see. So Friday, 9:30, you will contact my court coordinator and she will let you know where to appear, and that's it. Please log off. If
Your
not,
Honor,
we'll remove you.
give me one
Please
second.
log off. No, Ms. Olivares, 9:30 on Friday, we'll take everything up. All parties log off or I will remove you. We're off the record on that case. All right, let me go ahead and recall F3808-18-9 in the matter of the marriage of Blanca Gomez and Mr. Guillen. Mr. Hinojosa and Mr. Espinosa, are you back on?
Yes, Your Honor. I'm here on behalf of Mr. Espinosa. I'm getting Mr. Espinosa on the line. Please just give me a minute.
Okay.
Judge, if you can just get the interpreter's name for me, please.
Yes, wait till all the parties are on and we're gonna go through all the formalities of all of that. Because there are some questions that I also have to ask him as well.
Okay.
Your Honor, Mr. Espinosa is currently logging on to Zoom.
Mr. Hinojosa, were we going to be waiting for your client, Mr. Guillen? Mr. Hinojosa, I think you have a very bad connection. You may want to log off and log back in. Mr. Hinojosa, did you get a better connection? No. Your audio is not good, sir.
Their machine.
Okay, you're still breaking up. Go ahead and talk again?
Yes,
test,
Judge. Test.
Go ahead. Is Mr. Hinojosa in another hearing?
He's in County Court at 6, County Court at Law number 6, Judge, this morning. He's just making a quick announcement.
Okay, well, your audio is much better.
Thank you, Judge.
Okay, just let him know that that's it. We're only having his case. So to please just jump in and we'll go
Yes.
ahead and wait for him. We'll be on
Okay.
standby.
We'll let him know, Judge, right away.
Okay, so we are off the record. As soon as Mr. Hinojosa comes on, we'll see. We'll give him about 5 minutes. So let's reconvene in about 5 minutes. If the translator and the interpreter wants to let Ms. Gomez know that.
Sí, señora Gómez, están esperando al señor Hinojosa, está en una audiencia en la corte número 6. Vamos a empezar ahorita con unos 5 minutos. Vamos a esperar al señor Hinojosa.
Ok, está bien.
Okay, we're off the record.
Thank you, Judge.
¿Quieres café? ¿Quieres café?
No, gracias, aquí traigo.
Okay, I see that Mr. Hinojosa is back on. Let me just check if when my court reporter's ready.
I'm ready, Judge.
Okay. Let me recall F3808-18-9. All right, so before I take announcements or hear anything, let me just, I don't know if some of you were privy to what just happened right now. Look, we're not gonna talk over each other. It's gonna be one at a time. If we can't do that, you need to let me know now so that I can set this for an in-person hearing and we can go ahead and take it up in person. Gentlemen, I'll give you an opportunity to respond. Can we do this?
Yes.
Okay,
Judge, yes, absolutely, we follow the rules on that.
okay.
If I can just let my client know.
Judge, let me just explain to Ms. Gomez right now in a minute as well.
Sure.
No. Señora Gómez, me informó la juez que en esta audiencia nadie va a hablar sobre nadie, vamos a hablar uno a la vez. Si eso no se puede hacer, entonces la juez va a hacer que tengamos una audiencia en persona. ¿Entiende usted eso?
Sí.
Okay.
Okay, so then I'm gonna allow, how much time are you all going to need for this hearing?
Judge, it's our motion. I think it's going to take about 5 or 10 minutes just to explain the motion with a couple of exhibits that were entered. So I don't expect, more than 20 to 30 minutes total. And we will be asking for the court's interpretation or clarification of a final decree.
Judge, if I may respond, Judge, I do think this is more of a legal issue, legal argument. We're arguing that there's no need for clarification, and this clarification is really more of a bill of review that should have been filed or could have been filed. And basically this, right now, there's no jurisdiction to clarify. There's no points to clarify, Judge.
Okay, so then, we're gonna finish this by 11:15. That's point number 1. So if the interpreter wants to let Ms. Gomez know that.
Señora Gómez, el abogado Espinosa le está informando a la corte que queremos que se clarifiquen algunas cosas que en la orden que se mandó hacia la corte, el señor Abel Hinojosa informó a la corte que él está en contra de esta orden y que no se debería hacer en primer lugar. La juez nos informó que esta audiencia no va a tardar mucho, sino que va a durar hasta las 11:15.
Okay.
Okay, first of all, let me have your interpreter raise his right hand. Do you swear that you will be interpreting as accurately as possible for Ms. Gomez?
Yes, Your Honor.
Okay, and you can lower your hand.
Thank you.
So, and are you a certified interpreter or are you interpreting just to assist Mr. Espinosa today?
I'm interpreting to assist Mr. Espinosa and our client. Your Honor.
Okay, all right. So then go ahead, Ms. Gomez, please raise your right hand.
Señora Gómez, por favor, levante la mano derecha.
And also Mr. Guillen, please raise your right hand. Do you swear that the testimony, do you swear that?
Forgive me, John, I'm going to get to translate also, Mr. Ginn. He does not speak English. I'm going to have somebody from my office, or if Mr. Espinosa wants to, if the court wants to have just one interpreter, Judge.
I can't force, I mean, that would be more efficient, but I cannot force him to interpret for your client. So go ahead and have somebody come in.
Yes, ma'am.
And that's if necessary. Please let Ms. Gomez know that they're getting an interpreter for Mr. Guillen, so to please just be patient.
Yes, Your Honor. Señora Gómez, ahorita el abogado Hinojosa está agarrando a alguien para que interprete para el señor Guillén. Si les puede esperar un momento, por favor.
Okay.
Okay, now you can, are you ready, Mr. Hinojosa?
Ready, Judge.
Okay, so now Ms. Gomez, please raise your right hand, and Mr. Guillen, please raise your right hand.
Señora Gómez, por favor, levante su mano derecha.
Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Señora Gómez, ¿usted jura que el testimonio que va a proveer ahora es la verdad, solamente la verdad, ante Dios, lo promete?
Lo prometo.
You have to interpret what she says.
She says she swears.
Okay, and Mr. Hinojosa, your interpreter for Mr. Guillen?
Mr. Guillén, ¿usted promete decir la verdad y solamente nada más la verdad y lo jura ante Dios?
Sí.
Yes.
Okay, you may lower your hand. Okay, and for the record, the interpreter for Mr. Espinosa, what is your name, sir?
My name is Eric Espinosa.
Okay, and the interpreter for Mr. Hinojosa's office, what is your name, ma'am?
It's Irene Godinez.
And Ms. Godinez, just like I asked Mr. Eric Espinosa, you will be interpreting for the purpose of assisting Mr. Hinojosa today, is that correct?
Yes, Your Honor.
And you are not a certified interpreter, is that correct?
Yes, Your Honor.
Okay, can I please have you raise your right hand? Do you swear that you will interpret as accurately as you can, ma'am?
Yes, I swear.
Okay. Lower your hand. All right, so Mr. Espinosa, I'll go ahead and since it's your motion, you can go ahead and state your argument.
Thank you, Judge. This is a motion to clarify a divorce decree that was entered in 2019. June of 2019, the decree states that there was a division of property. There was a house that was divided. And the house, as stated on Exhibit A on the decree, page 28, Ms. Gomez was to be reimbursed for $12,438.
Señora Gómez, el abogado Espinosa acaba de informar a la Corte que esta es una moción para interpretar o clarificar la orden del decreto de junio del 2019. Ahí se estipula que la división del hogar en la página 28 y le iban a pagar a usted una suma de $2,438.
¿2,000?
12,000, discúlpeme.
Ah, ok.
And Judge, we don't, we're asking the court to clarify that that was the actual amount, or if that was the amount that was to be paid to Ms. Gomez as per the decree and as per the transcript we submitted to the court as Exhibit B on page 24.
Sí, señora Gómez, estamos pidiendo a la Corte que clarifique la cantidad que se le debe a usted, ¿verdad? De acuerdo con el decreto que se hizo a su divorcio en la página 24. Es lo que estamos pidiendo de la Corte.
There was a,
Bueno, yo primero quisiera saber por qué se le da el derecho a él de tener la casa cuando yo también firmé un documento en casa del título, porque nada más él se ve como dueño de la casa.
Yes, Your Honor, Ms. Gomez is requesting to know, she's asking why Mr. Guillen is the only one that is to have, control of the property when she herself also signed off on the property.
and Judge, we're just, for clarification, should the court need any testimony from Ms. Gomez, she's willing to testify.
Señora Gómez, el abogado sí nos acaba de informar a la Corte que si se necesita su testimonio, usted está disponible para dar testimonio ante la Corte.
Tengo los dos.
So
She was
that's,
saying, hold on, she was saying something.
Señora Gómez, ¿está diciendo algo?
Sí, le digo que yo tengo los documentos donde yo firmé y firmó el señor Guillén cuando compramos la casa, o más bien se pidió el financiamiento para la casa, donde firmamos los dos, no nada más él.
Ms. Gomez is stating that she and Mr. Guillen both signed documents stating that, when they financed the home, that they both signed at the same time.
and so Judge, that's the clarification we're asking for, what is it the decree states on page 28 as to her just and right division of the real property of the house. And then also, as per the transcript, and the house is known as 3807 Vasquez Street, located in Pharr, Texas. And that's also stated in our motion that was filed.
Y señora Gómez, el abogado le está informando a la Corte que se le está pidiendo que clarifique el decreto de acuerdo con lo que fue la división de la propiedad que está en 6,807 Vasquez Street en Pharr, Texas, 78577.
Sí.
And the main reason for the motion, Judge, is because Ms. Gomez believes that she was entitled to more, or at least closer to a just and right division of the house.
Estamos pidiendo que se clarifique el decreto y estamos pidiendo esta audiencia porque la señora Gómez cree que merece más de lo que se le dio de acuerdo con el decreto.
Okay, before we move on then on that. So then the whole basis of this is that she really is contesting the amount that she was originally awarded?
Okay. Señora Gómez, la jueza acaba de informar que la razón por la que estamos teniendo esta audiencia es que porque usted está cuestionando la cantidad que se le había dado.
Yeah, yes, Judge.
Okay, however, there was, and I've read the transcript, so this was read into the record, is that correct, Mr. Espinosa?
Yes, it was, Judge.
Okay, so then the amount that she was awarded and she's not satisfied with that amount, is that what I'm hearing?
That's correct, Judge, and if I can.
Okay, hold on. And what page is this on the divorce decree?
I believe it's page 28.
Okay, and this is So this is a divorce decree that was not signed by Ms. Gomez. Is that correct?
That's correct, Judge. There was one original decree that that had a nunc pro tunc issue. So we submitted this one and it was submitted to the court.
Okay. Hold on before we move on.
Now-
So the non-pro-tunc issue was what? Refresh the court's memory.
There was a visitation issue, or I'm sorry, a geographic issue that was stated in the written decree that was not part of the record. So the written decree had a geographic restriction, but the transcript did not have anything about the geographic. So that was corrected on the nunc pro tunc, and it was submitted to the court. And if I can just state, Judge, I was not the attorney of record at that time. I was retained afterwards.
Okay. Okay. So however, the way that I see the transcript is both parties were present at their divorce hearing. Is that correct?
Yes, Judge.
Yes.
Okay. And it seems by the reading of this transcript, both parties heard the agreement as it was read into the record. Is that correct?
Yes, ma'am.
Okay.
That's the way I see the transcript, Judge.
Okay. And at the end, they were both asked if that was their agreement. Is that correct?
Yes, Judge.
And at the end, hold on,
Thank you, Judge.
wait. Okay, so she did it. So then she did state on the record on page 25 that she was not in agreement with the calculation that Mr. Hinojosa put on the record, which was $12,438. Is that correct?
That is correct, Judge. That's what I was going to basically point out. That is
Okay.
correct.
But she did state that she was satisfied with her former attorney's representation of her.
Yes.
And the way that I see it is that although she wasn't in agreement, the court issued a ruling for that amount. Is that correct?
Yes, Judge.
Okay. As a matter of fact, the court states in part, the former court, let me say, states in part, and a lot of times people do not agree with what the law may be, but that is basically the law. And I have to make decisions based on that law, okay? So he acknowledged in my point of view that although she was not in agreement with it, that he made a ruling based on the law. That's how I see it. And I'm making a statement. I'm not asking a question. Okay. So pretty much she's making the same argument that she was making on that day, that she's not in agreement with the amount of $12,438. Is that correct, Mr. Espinosa?
That's the basis of the motion.
Okay. Okay. All right. I'm going to go ahead and allow you to continue because this is your motion. but go ahead. And did you have anything else that you want to say, or you just wanted to state your position?
Yeah, so our position, Judge, is that amount, well, it be clarified, and if it's unable to be clarified, then we're going to ask for a ruling to allow us time to interpret or have the correct amount to divide the house or the assets from the house.
Okay. Mr. Hinojosa, I'll give you an opportunity to respond.
Judge, briefly, it's a legal argument. A court may not amend, this is Family Code 9.007. A court may not amend, modify, alter, or change the division of property made or approved in the decree of divorce or annulment. What we have here is a final order. All parties represented by counsel. Ms. Gomez did not agree with the court's termination. There was instructions as to inception of title rule as to the real property. There was a explanation about the real property, Judge. What we're doing here is not clarifying. What Mr. Espinosa is trying to do is to basically change the order. I don't believe this is a clarification, and a clarification will be denied. If Mr. Espinosa wants to challenge this, he has a right to a bill of review to challenge this, or they could have filed a motion to draw back then. But this is not the proper forum for this, Your Honor. So I'm asking for the clarification petition be denied and dismissed, Judge. Purely legal argument under the Family Code, Your Honor. Thank you.
Okay, Mr. Espinosa, did you want to reply to that?
Judge, only that, we're asking the court on how it reads the transcript and how it reads the decree, on what the court meant, or the prior court, what it meant at that time, so my client can understand exactly what the court's ruling was as to the division of the assets or the reimbursement.
Okay, so the way that I read the transcript, which is going to be what you should use as controlling to your divorce decree, is that she did state on the record that she didn't agree with that amount. Go ahead and interpret that.
Señora Gómez, después de leer el transcript, ¿verdad?, que agarraron de la corte, de la audiencia pasada durante el decreto, usted había dicho que no estaba, ¿verdad?, no quería tampoco firmar, que usted no estaba de acuerdo con lo que había dicho el juez en la audiencia pasada, ¿correcto?
Correcto.
However, that court, the way that I read the transcript, after hearing Ms. Gomez's dissatisfaction and listening to the attorneys, sided with Ms. Hinojosa's calculation in the amount of $12,438.
Sí, aún así, la corte, después de haber escuchado que usted no estaba de acuerdo y también haber escuchado lo que el señor Hinojosa había dicho, decretaron que se le diera la cantidad de $12,438.
Sí, o sea, no me escucharon. Hicieron lo que quisieron.
Translate that, please.
She said, yes, that is true. They did not listen to me. They did whatever they chose.
Okay. And just for the record, that's the previous court. I did not hear the divorce. Does she understand that?
Para su información, señora Gómez, ella no fue quien decretó eso, fue la corte anterior.
Sí, yo sé que fue la corte anterior.
She is aware that it was the previous court.
Okay. However, the court issued a ruling after hearing both attorneys, and that is the ruling that she would be entitled to the amount of $12,438.
La corte anterior, ¿verdad?, después de haber escuchado, ellos decretaron, ¿verdad?, esa decisión después de haber escuchado su posición y de los dos abogados en este momento. Entonces, eso es lo que se le dio a usted, los $12,438.
Okay,
Sí, entiendo.
go ahead and interpret that.
She understands.
Okay. So when a person doesn't agree with a ruling of the court, a motion to clarify is not the proper pleading. A person would need to file a motion for new trial within 30 days. And if it's been longer, then they would need to file a bill of review.
Sí, señora Gómez está informando a la corte que cuando alguien no está de acuerdo con lo que se dijo en la audiencia pasada, la orden que se hizo hoy, ¿verdad? La motion to clarify para clarificar, no es la orden adecuada, sino que se debería hacer. Just can you repeat the other motion? I apologize.
It would not be a motion to clarify, it would be a bill of review or a motion for new trial within 30 days of the date that the order was signed.
Thank you, Your Honor. Sí, dijo la juez que la orden esa que se hizo al principio no era la adecuada, sino que se tenía que hacer una orden, ¿verdad? Para que se dice a bill of review, o si no, se tenía que haber hecho una orden de new trial o una nueva audiencia 30 días antes de cuando se fue el último decreto.
Okay.
So, hold on, I'm looking at something else in the transcript.
De hecho, yo nunca entendí por qué la corte había firmado algo sin avisarme a mí. O sea, se suponía que eso era un borrador lo que me habían dado.
She says that she does not understand why the court signed a document without her notice.
Okay. Does she remember testifying that the court asked her if everything was explained to her and she said yes?
Pero como si se acuerda en la audiencia pasada cuando la corte le preguntó a usted si se le había explicado todo lo que había ocurrido en esa audiencia y usted había dicho que sí.
No recuerdo.
She doesn't remember, Your Honor.
Okay, perhaps she may request a copy of the transcript from her attorney, and it is on page 25.
Sí, usted puede pedir una copia del transcript que se hizo para que usted pueda revisar eso en la página 25.
Bueno, de hecho, de la última corte que fue del 2019, eso sí lo recuerdo cuando yo dije que no estaba de acuerdo con lo que ellos dijeron. Eso sí lo recuerdo y siempre lo he dicho.
She remembers the hearing of 2019 where she said she was not in agreement.
And the court now agrees that she was not in agreement. However, being not in agreement and the court issuing a ruling are very two different things.
La corte estaba consciente de que usted no estaba de acuerdo cuando cuando tomaron la orden y tomaron el decreto. Aún así, usted que no esté de acuerdo y que cuando la corte tome una decisión, no es la misma cosa.
Okay.
Now, just for my understanding, what is the amount that she feels that she is entitled to, Mr. Espinosa?
Señora Gómez, para que la jueza entienda qué es la cantidad que usted espera que reciba.
Judge, there was a house that there wasn't any exhibits, and I think Mr. Hinojosa, since he was there, will testify. There was no exhibits as to appraisals as to the house, but she believes the house was worth closer to 100,000, and she was entitled closer to half of that.
Okay. So unfortunately, the things that she should have done during the divorce, now it's too late, such as requesting an appraisal, such as just not entering into any type of agreement, or perhaps maybe better yet, stating on that day that she didn't want the hearing to go forward because she didn't feel that those issues had been addressed. And unfortunately, at this time, it's I don't want to say it's too late because she does have some other remedies, but this is not the remedy for her. And if she's not in agreement of that amount, she stated it back then and she's stating it now. And I do hear her. However, based on what my judicial limitations are at this time, it's to look at what's in front of me, and that's a motion to clarify. So I feel that this would be more properly addressed if it would be under a bill of review, and it needs to follow the appeals process. And she did state that she was satisfied with her attorney's services. So that also leaves an open-ended indication that she was okay with everything that happened during the process or how things were calculated. She never once asked on that date whether they should do an appraisal or there was a lack of an appraisal done. And based on that, the motion to clarify is denied. However, that doesn't mean that she doesn't have any other legal remedies.
Understand, Judge.
Okay. And anything else on this then?
Judge, one point, if I may. My client has tendered a $5,000 cashier's check to Mr. Espinosa's office in order to help satisfy part of the $12,438 judgment, but they're not cashing it. I don't know if they're refusing to accept payment on the judgment or what. I'm gonna have to instruct my client to put the money somewhere else because we're making payments, but they don't want to accept it.
I don't know. I mean, Mr. Espinosa, is it maybe they're not accepting payments right now because to them, it would mean they're accepting that judgment. Is that what I'm understanding, Mr. Espinosa?
That's my client's position, yes, Judge. And so
Okay.
at this point, I can either return the checks to Mr. Reynoso or forward them to Ms. Gomez, which I did forward one check to Ms. Gomez and she returned it to me. So it's now back in my possession.
Okay. So the interpreter, Mr. Eric Espinosa, let her know or ask her, is she refusing to accept any payments at this time on the judgment that has been ordered by the previous court?
Señora Gómez, ¿usted está, ¿verdad? Está refutando recibir pagos relacionado al decreto que se hizo?
Sí, me gustaría primero que se aclarara o que fuera algo más justo.
She would want it to be clarified or something more just.
Okay, let her know that her motion to clarify has been denied and the previous court's order stands.
Yes, sir. Sí, la Corte ha decidido que la moción para clarificar ha sido negada y que la orden de la Corte anterior es la que está en efecto.
So at this time, he is only ordered to pay her what is that amount that the previous court found to be just, which is the 12,000. Let me go back to that page, $12,438.
En este momento, señora Gómez, el señor Guillén nomás está obligado a pagar lo que se ordenó en la audiencia pasada y que la Corte ha dicho que es lo justo, que es la cantidad de 12,438.
And unless she's going to file under the appeals process, then any payments that he makes will be credited towards the $12,438, and cashing them is going to be up to her.
Al menos que usted quiera apelar, ¿verdad? Los pagos que haga el señor Guillén se van a ser creditados, ya si usted decida canjear el cheque o no.
Ok, bueno, entonces, no, pues ya no, ¿qué puedo decir? Porque fueron 16 años trabajando prácticamente para el señor, de gratis, porque pues se supone que eso es nada más una compensación y todo mi trabajo que...
After working for 16 years and paying for the house and working for the man, Commissioner. She says, now what?
I wasn't the one that heard the divorce, so I'm not privy to any of those details.
Sí, como la señora, la juez no fue la que escuchó su caso durante el decreto, ella no está titulada a hacer esas decisiones.
Okay.
So if she's not going to cash those checks, then those cashier's checks need to be returned to Mr. Hinojosa so Mr. Guillen can see either about reissuing those checks to Mr. Hinojosa and he can hold them in his IOTA account, or Mr. Guillen is just responsible for paying at the time whenever she decides that she will be accepting this judgment.
Si usted no va a canjear los cheques, en este momento, ¿verdad? Se le van a regresar al señor Guillen y ya decidirán si ellos lo van a poner en alguna cuenta o si van a pagarle a usted cuando usted decida aceptar los cheques.
Ok, que los mande al abogado Espinosa.
She wants the checks to be sent to Mr. Espinosa.
Okay, so then she will be cashing those checks that have been already sent to her attorney?
Entonces, ¿usted va a canjear los cheques que se le han mandado al abogado Espinosa?
Probablemente.
Probably.
Okay, they're cashier's checks, so they expire and then they don't, sometimes depending on the bank, I don't know about reissuance. So if she's not going to cash them before the expiration date, then she needs to return them so he can have, so that money doesn't get lost.
Si no va a canjear los cheques antes de la fecha de expiración, necesita que se lo regresen al señor Guillen para que él pueda, ¿verdad?, mandarle otro cheque, porque como son cashier's checks, tienen una fecha de vencimiento y puede que el banco no los canjee.
Okay.
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 And I'm trusting the attorney Espinosa. Just talk to her and let her know, look, I understand that she wasn't in agreement then and she's not in agreement now, but I'm tied, my hands are tied by the law as well. And let her know that if she's not going to cash those checks and those funds expire, I mean, she's only, robbing herself of that money. So.
Señora Gómez, la corte está consciente, ¿verdad?, que usted no está de acuerdo, pero ella, ¿verdad?, ha hecho todo lo posible en su poder y no puede ser más de lo que la ley le permite. Ahora, si usted no va a canjear esos cheques antes de la fecha de expiración, usted va a perder ese dinero.
Sí, muchas gracias porque yo sé, bueno, al menos reconocieron que no debieron de haber firmado documentos sin mi consentimiento.
She wants to thank the court.
No. Interpreta.
She wants to thank the court for hearing her and for understanding that they should not have signed those documents without her consent.
Well, I didn't issue a ruling saying that because once both parties testify, and especially with their attorneys present, when a divorce decree is submitted to them, even with one party's signature, as long as it is in line with the ruling that was issued on that day, the court can sign it.
Sí, eso no fue lo que la corte está decretando, sino que ella está consciente de que como usted no estuvo de acuerdo, aún así, ¿verdad?, tuvo una audiencia, estuvieron de acuerdo ante la corte y con eso la corte puede firmar el documento o el decreto que se hizo en ese momento.
Okay.
So, okay, well, that's the ruling of the court, and please, Mr. Hinojosa, if you'd like, you can file an order to that effect.
We will, Judge.
Okay, anything else?
No, ma'am.
Nothing further, Judge.
Okay, best of luck to all of the parties.
Thank you, Judge.
Okay.
Thank you, Judge. Have a good day. Can we be excused?
Yes, sir. You all may be excused. Thank you.
Thank you, ma'am.
Okay, that concludes this morning's